This week, we are starting our series in earnest on the different stages of a criminal jury trial. And this week, we're talking about stage one, the very first stage in any criminal jury trial, and that's pretrial motions. A stage that doesn't get discussed a lot, doesn't get a whole lot of love in the media or movies, but is super important. So let's talk about why. Happy Friday, everybody. Hope you're having a great week and gearing up for another good weekend. So this is the first actual stage in our series of the stages of a criminal jury trial. We're talking about pre-trial motions. This is a stage, even though it's technically before the trial starts, it happens before the trial starts, it's so ingrained in the trial process. It's so important to the trial process that it's only right to discuss it as a proper stage of the trial. So pretrial motions can really be referring to several different things. The first thing that they can be referring to that are fairly common are evidentiary motions, motions that request the judge to make specific rulings about certain either pieces of evidence or categories of evidence prior to the initiation of the trial. And this is why these pretrial motions are so important, because they can really frame how a trial is going to go. So evidentiary motions, one of the most common types of those is a motion to suppress. A motion to suppress is a motion that a lawyer on either side can file, and it's asking the judge to suppress certain specific evidence from being introduced at trial. More often than not, at least on the defense side, the argument for why it should be suppressed is due to its being retrieved illegally. So either it was an invalid search or seizure, it was done improperly, there's something about that evidence that means it's completely and patently inadmissible. And so those are typically some of the reasons why you would file a motion to suppress. Defense lawyers use these as a way to try to limit exactly what evidence can be introduced to a jury. There's a saying, and it deals mostly with objections or improper questions, but it's true about evidence too. And that's, you can't unring the bell. And what that means is if a jury hears or sees something, even if a judge instructs them later, hey, you're supposed to forget about that, I'm instructing you to disregard that and not consider it for any purposes, even though they will certainly try their best to adhere to those instructions, it's really hard for them to unhear or unsee something that they have. So a motion to suppress is used if you want to keep not only the evidence out from the trial so that the jury doesn't see it, but a motion to suppress means that the other side can't even infer or imply that that evidence exists. They can't elicit testimony that says that there might be evidence out there that the jury hasn't seen. So it's really powerful to try to limit that down. Another pretrial motion that is filed a lot of times is a motion to exclude certain testimony. So if one side has identified a witness that they want to proffer as an expert witness to give some opinion to the jury, then the other side can challenge that expert and say their expertise is either invalid or it's inaccurate, it's unreliable, it's not scientific enough. Therefore, it would be misleading for them to give an opinion to the jury. So these expert challenges a lot of times happen prior to the trial starting. And that's so both sides can be prepared for exactly what witnesses are or are not going to testify. And so these challenges to the expert, sometimes they're called Daubert motions because of the case that they were based on. Sometimes they're, and the federal side, called 702 hearings because the rule of evidence that dictates expert testimony is Federal Rule of Evidence 702. But regardless of what they're called, they are a challenge to the other side's expert witness and trying to limit what they can or cannot say so that both sides can be fully prepared. Another very common one in terms of pretrial motions is what's called a motion in limine. Those ones are filed in almost every case. A motion in limine is similar to a motion to suppress. It deals with specific or categories of evidence, and it is a request to the judge that the other side not be allowed to get into that evidence without first approaching the court and explaining what they're about to get into and why they feel it is admissible or relevant. So it's when one side or the other has some evidence that they're concerned about, that they think there might be an admissibility or an evidentiary issue with, but they don't have any legal grounds to try to suppress it entirely. So this often comes in the form of if a person is on trial and they have been arrested before, okay, they've been charged with different crimes before. What they've done before isn't necessarily relevant at all to the immediate proceeding. And in fact, there's a specific criminal rule that deals with that. It's called 404B, that talks about you're not allowed to use prior bad acts in order to try to justify a conviction in the present unless certain criteria are met. And so a lot of times what defense lawyers will do is they will notate on their motion in limine, judge, there's this specific evidence, this person has this prior bad act that we anticipate the prosecutor is going to want to testify about or get testimony out about. And we're asking that before they do that, they approach the bench so that we can have a discussion and a mini hearing on whether or not they're allowed to do that. The reason that those decisions can't usually be made prior to the trial is because most of what you're arguing about is relevancy. Is this relevant to what's being discussed in the trial? And a good judge will tell you, well, I don't know what is and isn't relevant as I sit here before the trial has started. I haven't heard any of the testimony. It could be that once we get to that point in the trial, it's not relevant at all. Nobody has said anything about it. However, if we get to that point in trial and we've had 3 witnesses that have hit the stand and have said, the defendant is a great guy and he would never do anything wrong. I've never known him to break the law. Well, now that information is very relevant because it directly rebuts something that has already been said. So that's why motions in limine are done the way that they are. It's a list of evidence that either side feels this could be an issue, and I know that the other side wants to use it. I'm not saying that they can't necessarily. I'm simply asking that before they do, they approach the judge, we talk about it, have a mini hearing, and then we have a discussion and the judge determines whether or not that evidence can be used at that time. So there are a multitude of other types of pretrial motions that could be filed. It's really this is where a really good lawyer can do some creative advocacy, because whether it's a motion to dismiss for speedy trial rights, a motion to dismiss for constitutional right violations, due process violations, whatever the case may be, there is an infinite number of pretrial motions that could be filed. The job of a good defense lawyer is to find the motions that make the most sense, that would provide effective relief to the client, and that have a good, solid legal or factual argument that they can present to a judge. So there's a ton of them, but this whole section of pretrial motions is super important. It is very routinely passed over and skipped over, and it is something that I think a lot more lawyers need to pay a lot more attention to. As always, if you have a question about this or anything else, please feel free to leave a comment below. Feel free to swing by the live stream on Sunday evenings at 7:45, and I'd be happy to answer whatever questions you have. Hope this was informational. I look forward to coming to you next Friday with stage number 2 of a criminal jury trial, and that would be jury selection or voir dire. So let's talk about that next week. But until then, I want everybody out there to be good, stay on the right side of the bars.